What are some of the major changes, right? What makes a 2012 student athlete categorically different from a 2025 student athlete? Obviously, the advent of NIL, the ability of student athletes at the collegiate level to monetize off of their own name, image, and likeness is something that was not really part of the discussion back in the 2010s, right? That over the course of the pandemic, the NCAA has lifted its restrictions on the ability of student athletes to receive compensation. At that point, it was from third parties and off-campus entities for the use of their NIL. We are now we have entered, we are squarely within the new NIL era, right? And as those restrictions were lifted, student athletes continued to advocate for themselves. They sued under a class action lawsuit that resulted in this new House settlement that went into effect sort of in full force July 1. In addition to that, though, right, I think a debate that we are continuing to have, that various stakeholders are continuing to invest in the college athletic space, is the question of whether student athletes are employees of their institution, right? Are they employees of the particular college or university for which they compete, right? I think my personal crystal ball has been relatively unreliable lately, but if I had to put money on a discussion that will continue and an answer that I think that we need as an industry, it's the student athletes as employees question.
How does the NCAA House settlement alter recruitment, in particular for younger athletes, given the type of monies that they're now going to be receiving?
Right. Well, to be clear, student athletes are not currently categorized as employees, right? There are several lawsuits. The National Labor Relations Board has weighed in as to whether student athletes are employees, right? I think some of them very much want to be categorized as employees. They want a steady salary, right? They want a biweekly paycheck. They want benefits. I think a lot of institutions and the NCAA in particular are very against that idea, right? There are concerns about what happens if a student athlete gets injured at that point. Is that a workers' comp claim, right? You have overtime concerns as student athletes, like I said, put in countless hours every week and every month to hone their craft. So at this point, student athletes are not deemed employees, just to level set. But in terms of the House settlement's impact on recruiting, part of that settlement, right, in addition to allowing Division I colleges and universities to pay their student athletes directly for the use of those student athletes' NIL, there is also sort of a restructuring of the number of kids that can compete on any given institution's team at any given time. There are new roster limits that have been imposed as part of this House settlement that apply to Division I institutions that have opted into revenue sharing moving forward, meaning that for some teams, there are going to be more opportunities and more roster spots. Some teams are getting bigger. Some teams are shrinking, right? And so in particular for middle school and high school athletes in sports that are going to see significant roster changes moving forward, they're going to have to do that number crunching, run the calculus themselves to determine their new likelihood of making it to a college team in their given sport, right? If for example, acrobatics and tumbling, right, that roster is expanding. The football roster is shrinking under these new roster caps, right? And so a student athlete is now more likely to be able to gain a roster spot on an acrobatics and tumbling or a stunt team, less likely to be able to clinch a Division I offer for a football program.